Whether you live right here locally or you are trying to manage an inherited house in Lee County, Florida, from thousands of miles away, you are likely facing the same overwhelming question. How much of this estate is going to be eaten up by legal fees? Most people think they are stuck in a long, expensive court process, but a major shift in Florida law on July 1st is about to change that. It's a hidden math secret that allows thousands of families to skip the slow lane entirely, and I am going to show you exactly how it works. I'm Michelle Miller, a Lee County real estate agent and a certified probate expert. I specialize in helping families navigate the burden of inherited property. I want to give you something valuable in the next few minutes because there is a deadline coming. And depending on your situation, it could save your family thousands of dollars. Florida's governor is being asked to sign a piece of legislation, House Bill 1337, that, if signed into law, will take effect July 1st, 2026. And it is going to change the probate game in a very significant way for families right here in Lee County. Here's the headline. Florida is raising the summary administration threshold, the fast-track version of probate, from $75,000 all the way up to $150,000. That means thousands of families who used to be stuck in a long, expensive court process, sometimes dragging on for a year or more, may now qualify a much faster, cheaper path. But here is the secret. Even if the house your family inherited is worth $600,000, it likely counts as zero toward that limit. Now, I am a real estate specialist, not an attorney. So while I'm going to show you how the math works, you should always verify your specific filing with your legal counsel. In Florida, the summary administration threshold only counts what's called non-exempt assets. Some of the most valuable things a person leaves behind are actually exempt, meaning they don't count toward that $150,000 cap at all. Here's what Florida law specifically protects. Though keep in mind, these exemptions aren't automatic. You must formally petition the court to claim them within a specific statutory window, or the exemptions are waived. The homestead, if the property was your loved one's primary residence, it is exempt. In most cases, the value of the home itself counts as zero toward that limit. Furniture, household furnishings, and appliances in the primary home are exempt up to a net of $20,000. Vehicles, up to 2 motor vehicles used as personal transportation are exempt, regardless of their book value, provided neither vehicle has a gross weight exceeding 15,000 pounds. Let's say your parents lived in Cape Coral and left behind a canal home worth $600,000. And they also had $140,000 sitting in a bank account. Under the old rules, that cash pushed you into formal probate. But if the new law takes effect, that $600,000 house wouldn't count. Only the $140,000 sitting in the bank matters. At $140,000, your family qualifies for the fast track. This applies whether you are inheriting in Cape Coral, Fort Myers, Bonita Springs, or anywhere in Lee County and the entire state of Florida. Now let's talk about one particular change this bill makes for families going through formal administration, because it matters if that's the path your estate ends up on. If the new law takes effect, a personal representative, the person the court appoints to manage the estate, gets clear, stronger legal authority to enforce their role. If someone, including a financial institution, refuses to cooperate with a valid court-appointed personal representative, the court can award attorney fees against the party that caused the problem. The message is simple. The proposed law is designed to have more teeth when it comes to enforcing what the court has already authorized. But I need to say something important about Lee County specifically. The 20th Judicial Circuit is one of the strictest probate courts in Florida when it comes to paperwork. They use a digital case management system called Odyssey, and there is a mandatory filing checklist that must be satisfied. If one single item is missing, your filing will be rejected before a judge ever sees it. That means you start over, you lose time, you pay more. This is not me being dramatic. This is the reality of probate administration in Lee County. And it is exactly why working with someone who knows this court system, a local probate attorney and a local property expert, is not optional. It is essential. Now, I need to walk you through two very real traps before you make any decisions. Trap number one is the 2-year debt rule. Summary admission is wonderful, but it handles debts different. While formal administration has a built-in creditor claim process, in a summary administration, you or your legal representative must proactively choose to publish a notice to creditors to trigger a similar 3-month window to bar future claims. If not, and your loved one passed away less than 2 years ago, creditors, including hospitals, medical providers, and the credit card companies, can still come after the estate under summary administration. And in some cases, the heirs can become personally liable for those debts. Formal administration does have a creditor claim period, and once that window closes under the right circumstances, it can significantly limit what creditors can pursue. That's a meaningful protection that summary administration does not offer in the same way. So, if there are significant medical bills or outstanding debts in the estate, the faster path isn't always the better one. An experienced Florida probate attorney can walk you through exactly how that works for your family's specific situation before you file anything. Trap number two is hidden assets. Here's a scenario I see more than you'd think. The family thinks they know everything in the estate. They file for summary administration. The case is moving. And then, 2 months in, someone discovers a savings account or a small brokerage account that nobody knew existed. If that account pushes the total non-exempt assets over $150,000, the summary administration case is voided. The court throws it out. You have to convert to formal administration and essentially start the process over. The takeaway here is simple. A thorough asset inventory before you file is not optional. Bank accounts, brokerage accounts, savings bonds, and cash checks, digital assets, all of it needs to be on the table. Your probate attorney will help you build that list, and it is absolutely worth doing carefully before anything is submitted to the court. Now, I know what some of you are thinking. Michelle, if the new law takes effect July 1st, should I just wait? Maybe, but that answer is different for every single property, and here's why. Every house sitting empty for Myers, Bonita Springs, or Estero right now has a clock running on it. We're talking about Lee County property taxes, vacant home insurance, which is significantly more expensive than a standard policy, and the cost of running the air conditioning continuously through May and June, because in Florida, if that AC goes off, mold doesn't wait. And then there is the legal side. The difference in time to sold between summary and formal administration, and how the 3 months credit window and when the court issues letters of administration actually determines when your family can access funds from the sale. Here's the concept I want you to walk away with. Every property has a tipping point, a date at which waiting for July 1st stops saving your family money and starts costing it. For some properties, that tipping point hasn't arrived yet. For others, it passed the last month. I offer a free property holding cost analysis where I look at your specific house and these specific variables together: the taxes, the insurance, the AC bills, the legal timeline, to help you find your tipping point. We'll decide together whether waiting for July 1st makes sense for your family or whether acting now is the smarter move to stop the money burn. The link is in the description, which brings me to the people I most want to talk to right now. If you are sitting in Ohio or Michigan or New Jersey right now, trying to figure out what to do with a property your parents owned here in Cape Coral or Fort Myers, I want you to hear something. You are not alone. Lee County has one of the largest concentrations of snowbird properties in the entire state of Florida. Thousands of families every year find themselves in exactly your situation, grieving, overwhelmed, and trying to manage a house from thousands of miles away. Here's what makes the new summary administration law particularly meaningful for you. Summary administration usually doesn't require traveling to Florida for court, which for out-of-state families managing everything from up north is a meaningful relief. And when it does come time to address the property itself, you have options, real options. You don't have to just take whatever the first investor offers you. Whether your family needs a fast cash solution, wants to do some light updates to maximize value with no upfront expense, or is ready for a full market listing, there are paths forward that protect your family's equity. The goal of what I do is simple. Faster probate means less time tangled up in legal, less time managing an empty house from another state, more time focused on your family. You don't have to figure out this math alone. Reach out to me for a free property holding cost analysis. There's no pressure, no obligation, just clarity. The link is in the description below. And if this video helped you understand something you didn't before, please consider sharing it with a sibling, a co-heir, or a family member who's also trying to navigate this. They need to know about July 1st too. I'm Michelle Miller. I'm right here in Lee County, Florida. And whenever you are ready, I'm ready to help.